The broadcast is now starting. All attendees are in listen-only mode.
Welcome to the Access webinar. My name is Ginny Cover. I'm an Access board member and mom to an adult with Klinefelter syndrome. Access is pleased to be able to host an overview of IEP and 504 plans given by Pete Wright, an attorney whose practice has focused on special education law. He's well known for his educational programs given nationally to parents advocating for their children, as well as his Wright's Law website. In addition, he's published a number of reference books, one of which will be used in the overview tonight. Mr. Wright will be discussing some of the challenges in obtaining services for children with X and Y variations and how to address these successfully for your children. We have a very large number of webinar participants, so we can't leave the phones open. You're all on mute. The speaker will take questions at the end of his presentation. We ask that you type them into the question dialog box on the lower right-hand side of your screen. If you simply phoned in, you can email questions to me at info@genetic.org. We can't answer questions that are specific to your child. He can only answer general questions about the law. Special thanks for the sponsorship of Endo Pharmaceuticals and Pfizer for this series. And now I present Pete Wright.
Thank you, Jenny. It's a great honor to be a presenter for you all and to provide the attendees with an overview about the law of IEPs and 504s. To really understand IEPs and 504s, you have to go back and get a basis in the law of IDEA and 504. But knowing the law is not enough to get services for your child. You have to understand how to market and sell to school districts to get doors open for services. So I'm going to be covering that today too. As a basis, and under the law, there is the Individuals with Disabilities Education Act. It's a federal statute in the United States Code, and then the U.S. Department of Education issues regulations. When you're trying to find the answer to a legal question, you want to start with the federal statute and then look at the regs. In the statute, there are 5 key sections. You're going to see that this evening. You have to you cannot be intimidated by this law. It is not rocket science. It is easy to understand. There are 5 key sections. 504 and ADA work hand in hand, and sometimes issues are best framed as a 504 issue and not an IDEA IEP issue. Other times better framed the other way. You have to understand the differences between both and when to use one approach versus another approach. When you think you have a handle on what the law says about something, then you may want to check and see if there have been any cases on that issue. I'm going to show you how to find cases on specific issues, and you'll be able to find them quickly and easily in the future. Effective advocacy has to do with marketing and sales, how you market and selling what it is that your child needs. It's not about your telling them, the school officials, what the law says. Their perception of you has a large impact on whether doors are open or closed. You always want to have documentation. When I had an active practice, all of my parents were given a steno pad and a ballpoint pen, and they had to keep a daily log of every interaction that they had with school officials. If we had litigation, that steno pad was powerful evidence. I'll be talking about that later. So what we have got now is in an hour, maybe a bit more than an hour, I'm trying to cram my 6-hour training program that I do around the country. So guess what? It's not going to happen. Instead, you're going to get an overview primer about law and advocacy. It's going to hopefully get you started in the right direction so that you're going to know where to look to find answers to the law or to figure out how to write this letter about their failure to do an evaluation or failure to implement the services that were in the IEP. All of the material tonight that you're going to be seeing is on our website and also in our books, and in much, much more depth than this short webinar. When I do my training, I use my books. All of the audience gets a copy of 3 of our books, and I open the books up, PDF files, and highlight portions. So I'm going to do that with you tonight too. When a proposed law goes through Congress, it's an act. Congress takes testimony. Does there need to be a law on this or on that? Eventually, if they decide there does need to be a law, then the statute provides right in the very beginning what is the purpose of the law. So generally speaking, laws, statutes, same thing, will open with the findings of Congress and the purpose of the law, and then we'll go into what are the definitions of various things, such as the definition of free appropriate public education, or this or that, or a child with a disability. And then the statute will have later sections that will get into the various rights and responsibilities of state and federal agencies, the rights of the citizens, how dispute resolution, litigation, appeals are handled. Basically, though, all the laws will open with findings of Congress, purpose of the law, then definitions, then rights and responsibilities. Pursuant to the Supremacy Clause of the U.S. Constitution, the federal law, the United States Code, in other words, rules. It is supreme. Federal regs, state statutes, and state regulations may not take away a right provided by federal law. So again, when you're trying to find the answer to a question, what does the law say about this or that? Look at the federal statute first, then look at the federal regulation issued by the U.S. Department of Education, then check out your state regulations and your state statutes. As I mentioned before, when I do a program, the audience does get a copy of our books. And I'm going to open up, this is our law book, the cover of our law book. I'm going to open up that first part of it. Bear with me for a minute while I change screens here. So again, here's the cover. That was when I was arguing the Shannon Carter case before the U.S. Supreme Court in '93. In the table of contents, we talk about statutes, regulations, commentary, case law. Commentary is a very powerful tool that is discussed in the book in more depth and also in my training programs. The law went into existence in 1975 after Congress did a comprehensive investigation in '72, related in part because of the Park and Mills case. It was found that many children, thousands of children in Washington, D.C. alone, where the Mills case was, thousands of children were not allowed to attend school because they had disabilities and the public school could not afford to educate them. They were suspended or expelled for financial reasons, not for behavior reasons. The book then has an overview about IDEA, and the chapter that I focus on when I'm doing my live training is chapter 5, and that you'll see goes from page 37 to 187 is where chapter 6, the regulations pick up, and the regulations go all the way up until 289. So those are 2 long statutes. And then we have FERPA and some of the Supreme Court cases in the table of contents. So let me go ahead and close that one, and then we'll go back into the slide, the PowerPoint program. So the first statute is the purpose of the law. Findings of Congress, the purpose of the law, then definitions such as eligibility, then state responsibilities, the law of evaluations, initial evaluations, reevaluations, eligibility, and the law of IEPs, and then the rules of procedure, due process, hearing, discipline. All of that is in 1415. So the only statute that you have to really have familiarity with is the 1414 statute, and in a subsection D that is about IEPs. Now, if you have evaluation questions, A, B, and C may be helpful to you, and another one being the definition of a child with a disability. But 1414 is the key primarily. But let's look at the purpose of the law. The purpose of the special ed statute is to ensure that all children have available to them a free, appropriate public education that emphasizes special education and related services designed to meet their unique needs and prepare them for further education employment, and independent living. So that's the purpose. That's the mission statement of this entire law. So whenever you're wrestling with something, how to write a goal, an objective, or whether or not we can do this or can't do that, go back to, well, what's the purpose of the law? So this is the primary purpose: to provide FAPE to meet a kid's unique needs, to prepare the child for further education, employment, and independent living. Primary purpose. Second purpose, to ensure that the rights of children and parents are protected. So let me take you actually to that statute now. So 1400, there's the findings of Congress, and it talks about economic self-sufficiency. And then jumping a couple pages over to 1400D, purpose. Purposes of the law: to provide FAPE that emphasizes special education and related services designed to meet the child's unique needs, prepare the child for further education, employment, and independent living. I'm adjusting the screen slightly, trying to get a little better. Oh, it's too big. I'll have to leave it at that. And then the second purpose, to ensure the rights are protected. The next statute, 1401 definitions, all of the definitions are in alphabetical order. So the first one is assistive technology device. Then it ends with ward of the state. So let's take a look at that one now. So 1401 definitions here. So you'll see assistive technology. The one that we're interested in is child with a disability. What is the definition of a child with disability? It's a child with mental retardation, hearing impairments. Next line. Emotional disturbance. Next line. Orthopedic impairments, autism, etc. So it lists a bunch of different characteristics. The key word is and then the next page, who by reason thereof needs special ed and related services. So that's the key. The mere presence of a disability does not make a child eligible for an IEP. The disability must adversely affect educational performance. The law was passed in 75. The final regs were not issued until August 1977. Litigation didn't start until 1978. The litigation was around two primary concepts: what's the issue of FAPE, what's an appropriate education, and also whether or not a kid was eligible. This statute was one of the key issues. The courts over time said what this statute means is that if a child has a disability, the disability must adversely affect the child's educational performance. That was later picked up and added. Those two words, adversely affect, was later put into the federal regs for subsequent revisions to the statute. And there's more detail now. The federal statute, the United States Code, that's the law passed by Congress, signed by the President. The Department of Education issued regulations. So the regs don't have as much of a legal force, but they do have power. They do have force. They are law. They're what is called the force of law. And you see the definition of a child with disability is very short. It doesn't provide you with a whole lot. The regs cannot take away a right, but can provide more rights. So let's look at the Reg 300.8. The definition of a child with a disability, it explains, and it has the same language we just saw before, adds a little more, and who by reason thereof needs special related services. And then it goes into more depth, 3 through 9, and then definitions of disability terms: deaf blindness, deafness, emotional disturbance, hearing impairment, mental retardation, multiple disabilities, orthopedic, other health impairment, which is used to cover many, many conditions. And here a bunch of different disabilities are listed, which adversely affects a child's educational performance. And so we just looked at the reg. In the definitions there, it also defines special education. So here is the definition of special education. Basically, it says specially designed instruction, and that's the essence of it. So special education is specially designed instruction to meet a child's unique needs. I do want you to look at 33, supplementary aids and services. So those are aids and services that are provided in regular ed classes so that kids with disabilities can be educated with non-disabled children in accordance with 1412A5. What is 1412A5? That's the least restrictive environment statute, mainstreaming statute, inclusion statute. So that's what this number 33 says, in essence, are that supplementary aids and services are provided in regular ed classes so the kid can be educated with non-disabled children in the least restrictive environment. So that's number 33. Now I want you to look, I'm going to go backwards on you, and we'll look at number 26, related services, which is on the page before. If any of you have our law book, then it may be helpful for you to grab it, and you can read along with me. I'm at page 54. So related services, transportation, next line, speech language, next line, PT and OT. The key is right here, the word design. Related services are designed to enable a kid with a disability to benefit from special education. So that's the key with related services, to enable a kid to benefit from special education. Now we're going to take a look at the evaluation statute, and that's in 1414. Now remember, 1400 is the findings of Congress, the purpose of the law. 1401 are the definitions. 1412 has state responsibilities and that least restrictive environment. For example, we looked at moments that we saw reference to it moments ago was in 1412. Now we're going to look at 1414, the law of evaluations. And a quick overview, what is in there is that there has to be notice to the parent of the procedures that are going to be used. No single procedure may be used as the sole criterion to determine whether a child is or is not eligible for an IEP. The timeline to determine eligibility runs from the date of consent, not the request date. The key word that I'm going to show you in a few minutes is the word or. The child is to be assessed in all areas of the disability, and parents are members of the eligibility team. They must be given the eligibility the report and the documentation that determines eligibility, and consent is necessary for the initial evaluation and re-evaluations. So let me open up that statute for you. So that's 1414 A, B, and C. It starts here. So the first part, A, is about evaluations, and then a couple pages further on, it is B. B is evaluation procedures, and then it has subsection C, additional requirements, and then D is all about IEPs. So when you're looking at a statute the first time or regulation the first time, pay close attention to the main header first. When I'm doing my live training, I have parents highlight in their book this statute. Then I have them go to the very first line of a statute, highlight that, and see how it's structured. Here it's lowercase a. I tell them, don't read. Just look for lowercase b. So they'll go several pages further on, and we'll eventually find lowercase b. And I tell them, then highlight lowercase b, then find lowercase c, highlight that, and then go back to the beginning and where you highlighted lowercase a and see if that has any subsections. And it does. So A is about initial evaluations. So then, and that's number one, A1, initial evaluations. So now you look for digit 2. Don't read any content. Just look for digit 2. When you're trying to find the answer to a question, this is how you want to do it. You want to have the main headings and subsections highlighted. And then see digit 2 is reevaluations, and you already had B, evaluation procedures, so you know that's it. So now you can go back and actually make sense of what this says. If you don't do it that way, you'll find yourself getting confused, very frequently getting lost and overwhelmed. And so in essence, for the initial evaluation, the procedures are to determine whether a kid is a kid with a disability. Let me make this page a little bigger here. Within 60 days of receiving consent, or if the state establishes a time frame. When Congress was revising IDEA, the prior edition was 1997, so we call that IDEA 97. When Congress was revising IDEA 97, they eventually came out with this one, IDEA 2004. With the old law, there was no time frame to do an initial evaluation. There was no time frame, just reasonable time. And they said there had to be a time frame. They talked about it being 60 days, 60 calendar days. But there were some states that had a shorter time frame, 45 calendar days. And so what Congress was thinking was if a state already has a shorter time frame than 60 days, then they shouldn't have to extend it to 60 days. They could leave it at the shorter time frame. But they didn't put the word shorter in there. It was an oversight. I urged the Department of Education in their regs to put the word shorter in their regs. The Department of Education didn't see fit to follow my advice. So this is a key word, is the word or. And then further on, it talks about consent for the initial evaluation is not consent actually for the services. And A2, I highlighted moments ago, that's the law about real evaluations. It does not have a timeline in there, but many states do have timelines for reevaluations, and most states have timelines for the initial evaluation. Some states simply adopt and incorporate as their own state regulations the federal regulations, but other ones will copy and paste these federal regulations, and some will have different regulations. But again, the state regulation may not take away a right provided by federal law, so always start with a federal law in your analysis. So looking at what's going on around the country, so it's 60 calendar days by the statute, but then it said or. So you have 30 school days, Michigan, Massachusetts, 35 school days. So you see, it's quite variable around the country. Most states follow this. Some of them say this, but then have some additional exceptions or criteria. I'm in Virginia, 65 business days. In Kentucky, Illinois, 65 school days, but that also includes the IEP, finishing the IEP. 1415C5, the LEA shall evaluate a child before determining a child is no longer a child with a disability. So a child cannot be exited from special education unless, in fact, there is a determination the kid no longer has a disability. One thing that we did is, prior to today, we set up a special, on our store, on our website, a special discount code, because some of you after this evening may want to get some of our books or publications. So we have I think I have a link that works. Here it is. Let me see if this is going to work now that we're online. Let's see what happens. Coupon code. Yes, here is our store. So, this is the law book that I'm using right now, and we sell that for $29.95, and you can get it PDF separately or get them both together. I'll also be referring to the From Emotions to Advocacy book, and two other books we have is the Test and Assessments books and all about IEP books, and then we also have our Year in Review books. These books, the 2015 and the 2016 books, have all of the U.S. Court of Appeals decisions in them that came out in those calendar years. Our 2017 book has been completed. We're just running into software problems with headers and footers before that goes to press. That will be out very soon, hopefully. But if you have the Access coupon, if you go in and click on order for any of these, at one point it'll pop up coupon, and you put in the code AXYS. And you will get a 20% discount. And that's going to be good until July 31. So we're going to have it for 3 months. You'll have a discount of 20% across the board, whatever else is on the website. Okay, 1415D. So going back again, repetition, review, refresh. 1400 is the findings of Congress, the purpose of the law. 1401 is the definitions. 1412 was the state responsibilities, and that also included the concept about the concept of least restrictive environment. And 1414 A, B, and C is all the law of evaluations and reevaluations. Now, with evaluations, the there's a twofold purpose. One is to determine whether a child is or is not eligible for an IEP. And second, if the child is eligible for an IEP, its purpose is to determine the child's educational needs. And that's actually spelled out there in the statute. Why do you want to know the child's educational needs, assuming the child is found eligible, in order to create the IEP? So this is the IEP statute. Now, we're not going to spend any time. I'm already halfway through on the clock, and we still got a ways to go. So I'm just going to just show you what is in here, and you can go through it in more depth. This incomplete statute is also on our website, so you don't have to buy the book. You don't have all of our footnotes and everything on their website, but we do have discussions about it. So for D, IEPs, it's got a bunch of different subsections. So subsections 1 through 7. So 1 is definitions, 2 are requirements of what to be in the IEP, 3 development, 4 is a review and revision of the IEP, 5 is multi-year IEPs, 6 is failure to meet transition objectives, 7, kids that are in prison. Kids in prison may still be entitled to FAPE and to an IEP, depending upon facts. So just a quick overview. Again, definitions. So you highlight each of the seven sections before you go look at anything, any content. So that was number 1, and then 2, requirement of the program be in effect. I'm not going to do that right now. I just want you to see that you do need to do that if you print out the statute or get a copy of it. And then under definitions, there are 3 subsections: the actual IEP itself, and then the team, definition of the team, and then the definition of attendance. I said there was 3, actually 4, and then transition. So there are 4 subsections. The key subsection in the IEP, though, is what is the IEP? It's a written statement for a kid. It has the kid's present levels of achievement, how it affects the progress in the general ed curriculum, etc., measurable annual goals, how the progress will be measured. Jumping over, a statement of program modifications and supports for school personnel also. So IEP is not just for the kid. Accommodations on any of the statewide testing. Projected date for beginning of services, frequency, location, duration of the services. Measurable post-secondary goals, if a kid's going to go on to college or higher voc ed. So that was the definition of the IEP itself, and you'll see there's no language in there about Common Core or standards of quality or state standards. That was the definition of the IEP. This is the definition of the team, who they are: parents, regular ed teacher, special ed teacher, etc., whenever appropriate, the kid. Attendance. Attendance is not always necessary. There are exceptions that are included here in the statute. There has to be a written agreement and consent required if an educator is going to be absent. Number 2, requirement the program be in effect at the beginning of each school year. Kids who transfer from one district to another, it has within the same state or between states, outside. The language is the same. Kid is entitled to services comparable to those in the previously held IEP. If it's within state, the new school district does not have to do a new evaluation. If it's a between state transfer, then the new school district has to conduct an evaluation. Otherwise, those 2 statutes are identical. In developing the IEP, you have to consider the strengths of the child, parents' concerns, results of the initial or most recent evaluation, academic, developmental, and functional needs. Special factors. This is the statute that is the BIP FBA statute. FBA, functional behavioral assessment, and BIP, behavioral intervention plan, if the kid has behaviors that are interfering with learning. Many school districts have been tripped up by failure to complete an FBA and does not have in place a BIP. And so the kid gets expelled, disciplined regularly. Parents yank the kid and put the kid into a private special ed school, sue for tuition reimbursement, and are able to recover that because the school failed to prepare an FBA and then BIP for the child. The regular ed teacher is to be a participant in the IEP planning. The IEP can be modified without having to have the entire document redrafted. Review and revision is done not less often, at least annually, or revised more often to address any lack of progress or the results of a reevaluation, such as the parents providing copy of a private sector evaluation to the school district. Multi-year IEP. This statute authorized IEPs for 3 years. There's not a school district in the country that has done that, so that can be disregarded. And then the rest of the statute, if there are transition services such as voc rehab and the other agency drops the ball, the school district has to pick the ball up. Procedural safeguards 1415D of the statute. So this is 1415D, and this talks about parents' rights, but the key part here is to obtain the right to obtain an independent educational evaluation. So 1415, and one of the key things is that this is the IEE statute. It's also the statute that has all the law about going to due process hearings, going to court, discipline, a number of other procedural issues. The other part about IEE is in the regs. So the IEE portion of the regs is right here, 300.502, that parents have the right to obtain independent educational evaluation at public expense. And we have quite a few articles on our website about that. Now, if the parent requests it and the school says no, then they have to file a due process complaint against the parents to show that their own evaluation is appropriate, or ensure that they provide it. When there are parent-initiated evaluations and the parent then provides it to the public school, then the public school, the public agency, must consider it. It doesn't say they have to follow it or have to adopt it, but they must consider it. So here's the law on that. It's pretty clear. So a special education due process hearing is a mixture of a medical malpractice wrongful death case that has merged with an equitable distribution, divorce, and custody case. And why do I say that? Because it's a battle of expert witnesses arguing over shades of gray, and both have very, very strong emotional involvement in the case. That's the domestic relations analogy. Both sides feel betrayed by the other, and the case is being litigated pursuant to the federal rules of civil procedure. I always told my clients that if we win at due process, the school's going to appeal to federal court. If we win at the U.S. District Court, they're going to appeal to the U.S. Court of Appeals. If we win at the U.S. Court of Appeals, they're going to petition the U.S. Supreme Court for certiorari. I told my parents also, if we lose, and I think we should go on to federal court, then I will expect, and I tell you, I think we should go on, and I will expect you to do that. So I had my parents prepared for the case to go all the way up to the U.S. Court of Appeals. Now, what else is in this statute is all the law about mediation, appeals in two-tier states where you have a due process hearing officer or administrative law judge, and then it goes up to a review panel or review officer, and then it goes to federal court. Most states are single tier, so in that instance, the appeal is straight to federal court, and then stay put, discipline. All that's covered in the 1415 statute. You do not have to resort to a due process hearing. Sometimes, with regard to an issue, you can file a complaint with the state education agency or the Office of Civil Rights or the Department of Justice. I just already showed that to you. and that the agency must consider. I got ahead of myself on the slides. There was a case out of Cobb County, out of Georgia. School sued parents because they did not want to provide the IEE, Independent Educational Evaluation. It cost them more than $271,000. That case is written up in our 2016 year in review bill. Cost the school board more than $271,000. Last I heard, it was over $300,000. Section 504 is a civil rights law. The 504 and the Americans with Disabilities Act go hand in hand. Each incorporates by reference in large part the other. So you'd be thinking of both simultaneously in many issues. Its purpose is to protect individuals from discrimination. So an aid for field trips. It could be a 504 violation. If the parents have told your kid can't go on the field trip unless a parent goes, you can get dollar damages under 504 violations. The 504 child has a right of access and opportunity to the schoolhouse. The IEP child has the same right, but is also to have an appropriate education from which the child receives educational benefit. So IDEA equals all the entitlements and protections of 504. 504 does not equal all the entitlements and protections of IDEA. The 504 child can have allergies, asthma, diabetes, an episodic condition. Episodic condition, when you're reading any cases, if your child has a disability that's episodic in nature, and you're reading about asthma and your child has epilepsy, just substitute the word epilepsy and think of the case in those terms, because they are all same. Do not have tunnel vision. The law itself actually says shall be construed in favor of broad coverage. It's a disability that is episodic. On our website, we have a whole page about filing a complaint with the Office of Civil Rights and how to do that. We also have another comprehensive page about 504. And all you have to do is go into the index up in here, Google index, and just type in section 504, and you'll find these pages. I strongly recommend that you download two documents. One is the OCR resource guide, and get that under your hard drive. And before you go through it, take our 504 quiz. We have a quiz on our website. You take the quiz, and that will help you really understand the 504 resource manual. I took 11 scenarios in the resource manual and converted them. This is right out of their manual, but then I added the possible questions. I created the multiple choice quiz. So I recommend you take this quiz, and we provide the link for you to get the answers. The answers are on this page where I put the question and then the correct answer in bold, and then take the words right out of the OCR resource manual as to why that is the right and correct answer. So for those of you who want to get a much better handle on 504 ADA, doing this, take the quiz first and then go through the resource manual that they provided. Now, how do you find a case? All right, here's what you will usually do is have, when I do a live demonstration, I'll have this as my search term, the IDEA 2014. So first I'll open up Google Scholar. So it's now open. Click on case law, and I'll tell it to select. I'll tell it to select all courts. We'll do the whole world. We'll get everything out there. And then I'll click done. And then it says put your search term. So here it is, Individuals with Disabilities Education Act. And then I'll put in 2018. So now I'm going to get every case that has that exact phrase and the number 2018. And it came out with 274. And I'll tell them to sort by date. And so here's a case that came out 6 days ago in the District Court of Tennessee. And then here's one out of Minnesota 6 days ago. And another one out of Pennsylvania 6 days ago. So you can see you can get a lot of good stuff. And look at this, create alert. If I click on that, it'll ask me to put my email address in. And if I do that, I will get every day an alert of all the cases that have come out that have that exact search term. I'm going to change it and put in Klinefelter. Let's go ahead and edit this and put in Klinefelter. All right, here we go. So here's 2 years ago, 7 years ago, 17 years ago. All right, let's see. Chromosome, let's try that. Oh, here's a kid. So chromosome issues, and this was just a couple months ago. So you see, you can find a lot of stuff. You put in people's names, you can find stuff. If there is a due process hearing in your state, the losing party can eventually appeal it. Some states you have to go to review, other states you go straight to federal court. In any event, one way or the other, the losing party can take the case into the U.S. District Court, federal court, in their state, and then the losing party in that state can take the case up on appeal to their Court of Appeals in their circuit. So if there's a case that came out of Maryland last month, a U.S. District Court case out of Maryland, has no weight in North Carolina, South Carolina, Virginia, or West Virginia. But if that case went up on appeal to the Fourth Circuit and the Fourth Circuit issued a ruling defining something or clarifying something, that is all the law in the Fourth Circuit. But does not control any cases down, let's say, in the Ninth Circuit or the 11th Circuit or wherever else. There were 2 cases at the U.S. Supreme Court last year. The Fry case was about the ability to go straight into federal court if there was a violation of 504 ADA. Andrew was about the definition of FAPE. The From Emotions to Advocacy book, we're almost running out of time now, and I'm sorry for that. I want to show you what is in this book and what I tell parents all the time in my live training. I don't do a whole lot on the From Emotions to Advocacy book. I don't do a whole lot on it. I do tell parents they have to read this book 3 times. The first time the parent reads this book, they will go through an emotional roller coaster as they see themselves and their tears start to flow and they revisit things that have happened to them before. So here are the different chapters. And then I had some slides relating to several different things, how to deal with difficult people. We have a whole portion of the book is about that and the behaviorist communication, how to deal with pit bulls and bullies. Then I had some more slides related to the crisis. The crisis is going to happen. How you deal with it is what is critical. And then the importance of learning how to draft smart IEPs that are specific. That's chapter 12, measurable. Use action words, realistic, time specific. We have some depth on that. And then, remember I talked earlier about the importance of documentation. You have to document everything, how I had my parents keep a running log of everything that happened. And then most important, learning how to write the letter to the stranger, which is a letter that does not blame and does not finger point. Instead, it uses visual imagery and tells a story. So I think what we need to do at this point is ought to go ahead. We have about 11 minutes left, and let me switch it back to the moderator, and I'm going to open up another slide right now that will just scroll through, and it may be that you moderator may want to cut this off and replace it with your own screen, or this one can scroll through.
No, you've got plenty of time. We can go until 10 o'clock. So you've certainly got time to go through the rest of your slides.
Oh my gosh, I had the timer set wrong.
Right.
Okay. Okay. I'm like, well, hallelujah. I feel like I got a gift. Thank you. So, all right. Well, let me pick back up then. Well, at what point do you want to shift it over for questions? I have 9:20 on my clock right here.
I would say we can shift, you certainly talk for another 20 minutes because you have a number of things that you need to cover in the slides. So we can stop for questions at 9:45.
9:45. Okay, very good. Well, now let's pick back up. And now that I've kind of shown some of those things I was going to link to. All right, let me go back into the book chapters and table of contents. So as I mentioned a few minutes ago, I tell my parents to read this book 3 times. The first time they read it, there's going to be an emotional roller coaster, and you do not want to have a highlighter, you do not want to have a pen, just read it cover to cover. The second time you read this book, then you want to have your pen and your highlighter, and with your pen write notes to yourself and highlight critical portions. The third time, you just go back and skim through what you highlighted in the notes to yourself. Because what will happen is down the road, then something will come up and you'll say, oh, I remember there was a chapter of the book, in the From Emotions to Advocacy book, and you'll know where to turn to and be able to refresh your memory and go through that. So it's all about learning the rules of the game, and that there are predictable obstacles to success, and that conflict is normal and the crisis will happen. I always recommend getting private sector evaluations. Organizing the file is critical, and you have to have it done. We have 2 chapters about understanding the bell curve, understanding test data, and I've got a whole WebEx product on our website about that. Smart IEPs, and you can skip, if you have the law book, you can skip section 4. If you don't have the law book and don't really want to get it, then section 4 may be the thing for you, because it has an overview of these sections that we just looked at a few minutes ago. And you can disregard No Child Left Behind. That's history. That's replaced by ESSA. Section 5, Tactics and Strategies, the rule of adverse assumptions, creating paper trails, learning how to write good evidence letters, specifically the letter to the stranger, how to prepare for meetings and take control, and once you have control, how to maintain control of meetings. And yes, parents, you can do that, and that's by mastering several concepts. One of them is the 5 W's plus H plus E: who, why, what, when, where, how, and explain. In other words, learning how to ask questions using those 7 letters. And the other part is learning about advocacy, negotiation tactics, and how do you bring them into your advocacy. So now let's go to chapter 5. Chapter 5, we talk about how so often the parent themselves feels pity for the child and is overprotective, and that really can interfere with being a successful advocate for your child, and that there are difficult people in meetings, in all kinds of meetings, not just special ed meetings, and the personality types are fairly predictable. So we have more about that in here, and how to deal with some of the individuals, the pit bulls and the bullies and the know-it-alls, and etc. And here's the 5 W's plus H plus E reference, and that there are conflict avoiders in the meetings. And there are always wet blankets, and there are snipers and complainers, and yet you have to be able to deal with them. And all of this is pretty normal. So effective advocacy really boils down to effective marketing and selling over food. I tell my parents to bring food to the meetings. If you have a place near you that has these fancy party platters, bring 4 platters of food. 2 that are the heart-healthy celery, carrots, broccoli, and 2 that have all the good food, the donuts, or not the donuts, but the cookies, the chocolates, and the really good stuff. Bring 4 platters, 2 of each, and leave them. What happens is that later on, after the meeting is over, people will be talking about the food. Strangers, other teachers will come in, will sample it, and you become the spin doctor, and the perception of you will start to change. In sales people who really got to swing that big contract do it over food, over lunch or dinner meetings. When I had a dad, and I learned that the dad was in sales, and mom had a bad relationship with the school officials, it was going south quickly, and dad was not that involved. I got dad involved, and I would have him go to the meeting, not the mother, because the salesperson knows that when you are told no, we cannot provide that service to your child, the salesperson doesn't hear the word no. They hear not yet and the opportunity for another meeting. And I'm going to bring you some more information that will help you. And I'm going to bring some good food this time again, too. That's what markets and sells. And you're in marketing and selling. Always be nice and present a merged personality of Peter Falk Columbo and also Mrs. Manners, but document everything. Always have a paper trail. So I just showed you chapter 5. Special ed law makes conflict inevitable. And why is that? Because the statute empowers parents as equal partners on a joint task to develop an appropriate education that provides educational benefit. And yet the school is responsible for implementing that plan. So that in and of itself lends itself to conflict. When you have conflict, you have two goals. One, to resolve the problem. Second, to protect the parent-school relationship. Why do you have to protect the parent-school relationship? Because you are in a marriage without the possibility of divorce, and your kid will be caught in the middle. So you have to protect the relationship for the benefit, for the sake of your child. There will be a crisis. So often the problems repeat themselves from school district to school district across the country. The names and the dates of birth change, but the problems are the same. When the crisis hits and you feel like your kid's going to be harmed, you get a call from the school on the voicemail, and they tell you to call back immediately. They send you a letter home. You got to call immediately. When you have to do something immediately, the crisis has hit, what should you do? What should you do? The crisis hits. What do? You got to protect your kid. What do? Nothing. You do nothing. You let it sit. You let it have 24, 36, 48 hours to think through how to turn a lemon into lemonade, and you do not want it to get any more polarized than it is, and you want to keep your kid out of it. So let me jump over to chapter 7 now. They're all predictable problems, and they've happened to many parents elsewhere around the country in many different school districts, and so often the problems are so similar. The names of the kids and the names of the school districts change, but that's about it. So what do? You do nothing. You're in a fragile state. Do you start a fight with no ammunition? No. So you got to think through the short-term solutions, controlling your emotions, keep your kid out of it. Having a neat, organized file is so important. Each chapter opens with a quote, do the hard jobs first, the easy job will take care of themselves. On my computer, my Evernote program, I have a file that opens first thing. It's my to-do list, and I had this as one of my things at the very top. Do the hard jobs first, the easy jobs will take care of themselves. And then I also have a quote just below that, do not let the urgent crowd out the important. I'd like to think those two quotes keep me on task, but I must confess I sure get immediate gratification from getting those easy jobs knocked off the list quickly, and enables me to push the hard jobs back another day or two. But Dale Carnegie says, do the hard jobs first, the easy jobs will take care of themselves. And that is so true. And do not let the urgent crowd out the important. Organizing the file is not easy, but when it is organized, then you are less anxious, you are more confident, you are in control. And it is such an important concept. I've got a whole YouTube video all about that. Let me take you to the Wright's Law channel, and you'll see in the Wright's Law channel this link right down here, organization of the file. And so there you go. I can make that full screen, but I won't. But I will stop on that one. Also, Diana Henry King, my tutor, the expert in dyslexia, and I did a decoding dyslexia keynote and a big case of the Ninth Circuit, Section 504, retaliation for the military child and DOTIs, the Department of Defense instructions, MIC 3, and then Medicaid fraud, response to intervention. When I do my live programs, I also open with my report card. Here's my report card. Parents are entitled to copies of their child's test protocols. and my introduction, typical introduction, and then a couple other, I guess, family ones got up in the Wright's Law Channel. I was sworn by dolphins on the Chesapeake Bay when I was at my kayak, and then my son at his wedding, and they were doing some dancing on the floor. What's the the adult turned to teenagers. Let me go back to this. So get the file organized. When it's organized, then you are less anxious, you're more confident, you are in control. Organize everything in date order. I spell it out in detail in the YouTube video. Smart IEPs, and that's chapter 12. You want to have IEP goals and objectives that are specific, measurable, use action words, realistic and relevant, time limited. And then we go into depth with those and how to draft them. My Carter case, Supreme Court case, her IEP said she would go, the Shannon Carter would go from the 5.4 to the 5.8 reading grade equivalent level as measured by the Woodcock Reading Mastery Test over a year's time. That pretty much met the criteria of a SMART goal and objective, except that it had her falling further and further behind. That's what was wrong with that IEP. Had her falling further and further behind. After the Carter case in '93, school districts stopped using that. Up until that time, that's how goals and objectives were routinely drafted. School districts are now picking that back up again, and you will want to learn how to do that. We have a fair amount in that chapter about that. You got to have paper trails, contact logs, record of events, and I talked about the steno pad, calendars. We have a problem report that you can prepare, and letters. Learn how to write lots and lots of letters. How do you write good letters? Well, you know, if it wasn't written down, it wasn't said. If it wasn't written down, it did not happen. Parents all the time, especially when I'm doing it in my conferences, they'll come up to me and they'll say, my school district said this and they said that, and they're not going to do this, they're not going to do that. And then I'll ask them, well, now, did they put this in writing for you? Well, no, but they did say. And did you write a thank you letter to them for that in which you thanked them for clarifying for you what it was that they could not do or would not do? Well, no. Well, then they never said what you thought they said. You misunderstood. If it's not in writing, it wasn't said. You have to write a letter then that puts it in writing. My understanding of what we agreed upon the other day was this, that, so on and so forth. And we also agreed that my child does need more speech language therapy, but you don't have sufficient finances to provide it at this time, but perhaps next year when the budget is passed, you might be able to provide this speech language therapy that he needs this year. If I was mistaken, would you please let me know? Otherwise, I'm going to see about lobbying my legislators to get more funding for speech language. If you have any other suggestions, please let me know what they might be. So this chapter is about writing good evidence letters, and we provide a fair amount of information. And then further on, way down at the end, we even have a bunch of sample letters that can help kind of get you started on things. They have to have lots of carrier returns, get to the point, easy to follow, courteous, prompt the reader to do something, and be sure you get all your contact information, because oftentimes letters that are critical do get passed on to people higher up. And one letter one of my parents wrote ended up within the House Senate's Joint Armed Services Committee, the Joint House, I don't know the exact name of it, but the Military Joint Committee. A letter a parent of mine wrote in which it explained that the military regulations provided less rights to the military child in a military school than if the school on base was a public school or the military child attended a public school off base, that the military regulations provided less rights and the military child was shortchanged. And an actual comparison of what was in the Federal Department of Education regs versus the military education regs was provided side by side, and that got in their hands. And because of that, the military regs have since changed. And the parent had provided all detailed contact information, including telephone call and email, and got a telephone call from a legislative staffer in the Senate. The letter to the stranger is the most important letter of all. The chapter opens with a quote, "If you would persuade, you must appeal to interest rather than intellect." But I also say, if you would persuade, you must appeal to emotions rather than intellect. Get the person to respond emotionally in their gut to you, to your position. And if they emotionally feel your pain and want to, and feel it and want to right the wrong, then you will get the doors open. So your letter is written in a way that provides sufficient facts with lots of visual imagery that tells a story and does not blame or finger point. If you think about a stranger finding the letter on the street and reading it, then what's going to be the stranger's reaction? If your letter blames and finger points, their reaction is going to be one of feeling defensive for the recipient of the letter. If your letter tells a story and does not blame or finger point, it has a totally different impact on the stranger. Because in the end, if your case goes south and it ends up in court, it will be the judge's law clerk who's fresh out of law school, who doesn't have children with disability, who reads your letter in preparing to file for the judge and feels empathy and wants to right the wrong. That's the stranger down the road. So we have a whole bunch of things in this chapter about making a good impression. You know, you only get one chance to make a good first impression. So you're documenting everything and your attempts to resolve the problems. The storytelling approach creates interest, describes the problem solution, persuasive, creates sympathy, and in the reader's eyes, a desire to right the wrong, but also share your fear. I am so afraid my child is never going to be able to, whatever it might be, learn to read, to tie his shoes, will never be able to get a job. Share your fears, but also be clear, what is it you want? Don't just say, and I want you to provide an appropriate education. That doesn't do it. I want my child to learn this or to learn how to read or whatever else it might be. Being clear and specific. In preparing for meetings, we have the pre-meeting worksheet, and you got to get the file organized. We have an agenda in there and handouts such as in chapter 10 and 11, we talk about the bell curve and preparing charts of your child's reading, writing, arithmetic, spelling scores, or speech, language, expressive or receptive language scores, whatever else it may be. But you can create bar graphs and charts of those to show progress, regression, what it is your child needs. My parents also had to read this book, and my Pam and I taught law school at William & Mary for 3 semesters, William & Mary School of Law, to help them get their special ed law clinic up and running. And our students had to read this book, Getting to Yes. When you master, this is a quick, easy to read book. When you master this book, when you have read it, you will then understand how to present to the other side at a meeting. You will learn how to say to them, this is how I believe you see the problem. And you want to describe how you think they see it. And this is how I think you feel about it. And this is what I believe you want. And I think what you are most afraid of is such and such. And when you nail all 4 of those, you are about 75 to 80% down the road toward getting the matter resolved in your child's favor, because they realize you understand everything from their perspective. And that dissipates an awful lot of the anger, the hostility, and leads to effective problem solving. So be sure you know what you want, but be sure you truly understand their position and what they are afraid of, because you have 2 interests: one, to solve the problem, but second, to protect the relationship. But you have to keep your emotions under control, because your emotions have a negative impact on creative problem solving. And when there are meetings, you don't want to go alone. You should review the chapter on how to deal with difficult people. You think of the 5 W's plus H plus E, bring food. If you tape record, never do it surreptitiously. Always have it out in the open. Be sure you can do that in your state. And always write nice thank you letters after the meeting. Also, after the meeting, write down your own impressions. And if issues are unresolved, that's an opportunity for another meeting, but have additional information for the next meeting that supports your request. And be sure at the meetings you listen more than you talk, but you tell your story, ask questions, always treat the other side with respect. So in summation, basically, Parents need to understand the law, must recognize that if it is not in writing, it did not happen, must learn effective letter writing skills, must ensure that the child's file is organized, must understand principles of effective negotiation and persuasion. So once again, on our Wright's Law store, if you want to get any of the books that I use today, you can get them at a 20% discount off whatever you see on the website, so long as you put AXYX in the coupon code. If you don't do that, you ain't going to get it, and it's only limited to the products that we produce. We have some books by other authors, and it does not include those, just for our products. And it's only for online bookstores. You can't submit a purchase order or do it otherwise. You got to use the online thing, as it's all generated automatically. And I showed you the link already, and that's the end. And I have gone 2 minutes over. I am sorry, Jenny. 9:42.
Yeah, we do. We have questions that have come in both in the question box as well as by email. So I will see how many we can get to.
Okay. All righty. I'm ready.
Do I have to provide the school district with her diagnosis of trisomy X to get services? She has mild delays in a number of areas.
The statute says that they have to complete the evaluation process within 60 calendar days unless their state has a different timeline. What I tell parents to do is to write a letter. Well, first it will be helpful if they have outside documentation that is clear that there is a disability of some nature that does adversely affect educational performance. So then I would want the parent to write a letter to the school, again, looking at our letter to the stranger example, so that it creates empathy within the reader, and tell the story, what's going on with the child, why the child needs special education services of a particular type, what is it specifically that is needed and why, but don't have conclusions, instead have facts that cause the reader to arrive at that conclusion. So again, it's marketing and selling, telling a story. And if you really do want to have some documentation from a medical provider or psychologist or educational diagnostician, whatever it might be, that makes it clear that yes, something does exist. Take a look also at the child with a disability regulation that spells out some of the different characteristics, and you want to try to have it fit under one of those umbrellas. And so it's a letter, and in the letter, close the letter with, it is my understanding that pursuant to our state regulations such and such, that the evaluation and determination of eligibility must be completed by X days, 60 days, 65 days, whatever it might be, whatever is in your state reg. And since I'm hand delivering this letter to your office today, I believe it needs to be completed by so-and-so date. If I'm mistaken, would you please let me know? And what happens is they'll focus on, wow, the clock has started, and the person has the right regulation. This is a drop dead date for us, and their focus will be on that. And also, if there is a backlog, as so often there is, this name will go to the top of the list in getting the evaluations and determination of eligibility. Now, this is for eligibility for an IEP. This is not the same for a 504 plan. It's not required. The 504 doesn't have to adversely affect educational performance, because if the disability adversely affects educational performance, it should be an IEP. But if it's episodic, asthma, epilepsy, something of that sort, then it's different.
Okay.
I think would want to be.
Yeah,
yes,
I think the question here is that there are many parents who are reluctant to disclose the genetic diagnosis, the extra chromosomes, and they're asking whether or not they have to disclose this for special ed services, for an IEP.
I would think the way to deal with it, assume that they're worried about the bully in the school district, the administrator bully, or the teacher bully, who will use this against the parent and maybe to embarrass the child.
Yes.
Maybe because of the sex-related issue, I would have the geneticist or the expert in this area or the pediatrician with the family just explain this child has a genetic deficit, related or chromosomal deficit. Explain it in lay terms. Don't get into all the medical stuff that's going to be over their head anyway. But has it, lock it up that it has it, and how it manifests itself with regard to the kid's behavior. Mm-hmm. Behavioral kinds of things. They don't have to say that it is precisely X, Y, Z, and Z, or 1, 2, 3, and 4, but instead just simply has this particular thing, and this is what is going on with regard to the kid in terms of what's adversely affecting educational performance. Don't have to provide a detailed, specific label. But instead describing enough of the things so it's clear that there's something going on. Because there is a statute that I did not point out, but that a child does not have to have a clear label to be eligible. But that's going to be getting into another area that you may be able to avoid just by having a letter written by someone on their letterhead in which it's clear the kid does have something going on.
Oh, okay. I have another question. The neuropsych evaluation and testing that the district provided is very cursory. It emphasizes that she's only a year behind in reading and math and says nothing about her motor skill problems and anxiety. I want to have the district pay for an evaluation at a specialty clinic. There are 10 specialty clinics for children with X and Y variations in the country. So this parent wants to have the district pay for an evaluation at a specialty clinic so that all of her deficits are detailed. What are my rights to a specialized evaluation by experts in X and Y variations? This is a mom of a child with trisomy X.
The statute doesn't go into that specificity, but the parent needs to read the statute, the IEE. I did point that out, and also the regulation, and I put that up on the screen also. Would want to read that. Then we have quite a bit of information on our website. If they just type in IEE and then also a second search, independent educational evaluation, do both searches on our website because you might pick up some files that it might find and might not, and get a good handle on it. There's a fair amount of litigation out there because some evaluations can be very expensive, and some school districts use it as an opportunity to fight. If a school refuses to provide an IEE, independent educational evaluation, then as I showed you all the statute, they have to ask for a special ed due process hearing. But that can turn around and bite them in the rear end, as it did in that Cobb County case, because they're ending up paying the parent's attorney over $300,000 because of the battle. So the parent will, before going forward with and getting in the battle with them on this, do your homework. The parent needs to do their homework on IEE, the statute, the regs, the articles on our website, your own state's regulation on that IEE concept. It most likely is a carbon copy, cut and paste of the federal reg. It is in most states, but it might be something more specific, and there might be some state memorandums or policy letters also on that, and the feds have even issued a policy letter on it. It may well be, given the unique nature of the child's disability, you can argue successfully for a unique comprehensive evaluation that may well be out of state and elsewhere. For a more garden variety issues such as LD with ADD or even autism, you might not be able to go from one coast to the other to get the expert top LD or autism evaluator, because there may be one, around the street or over in the next county kind of a thing, and the cost differential can be taken into account. But again, where you have some exceptional circumstances, as you would here, then you may well be able to get approval for the more expensive. If they won't do it, they've got to ask for a due process hearing. And many school districts, this is especially true in California. In California, a number of school districts, once a parent asks for an IEE, the school district right away, just very quickly, ask for a due process hearing against the parent, and they make it into two issues. One issue being that Mr. Hearing Officer, Mr. Administrative Law Judge, our evaluation is appropriate and proper, and also we want a ruling that our IEP, the present IEP, is also appropriate, even though the parent had not attacked the IEP. And if the hearing officer, administrative law judge takes the bait on that and goes into the current IEP, then the door to the parent is closed later to go after that IEP as not being appropriate, because there's already been litigation, and it's called res judicata. So they have to be aware of that, some real subtleties that are out there.
Okay.
And there may even be some special ed. In many states, you can read due process hearings out of your state just by typing in the state name and then typing in special education due process hearings. And you may even find some special ed due process hearing decisions and on IEEs in your state. And most certainly research it on Google on your state and your circuit, IEEs, as I demonstrated earlier.
Okay. What can you add to an IEP for a child with some behavior issues due to being bullied so that they don't keep getting school suspensions?
That's the two things really kick into my mind is that as I was listening to you. First, I did reference that statute, the FBA BIP issue, and so what are there behaviors that the youngster is exhibiting that are lending them, that are such that are leading the kid to being bullied, so what can be done in that regard? And then second, also another part of the IEP statute, I referenced that it's not just for the kid, but also for the staff, for the faculty. So stuff can be added in there. And then another issue is to be sure that it's clearly documented in letters bullying is going on and it's not being addressed adequately. And there have been several significant cases where there has been bullying done. School district was on notice, took inadequate action, and the school district ended up getting nailed. There's a big case that's going on, in fact, down in Alabama, and it's in our 2017 year in review book, where there was bullying going on, and even bullying by the aid for the kid, in addition to the kids, and so you got to get it really documented and lock it up tight.
Okay. Many boys with Klinefelter syndrome are twice exceptional. How can we address difficulties with school districts that are not willing or able to provide supports or interventions for learning needs because they say that the child has a high ability?
This is a common problem across all disabilities. So often the kids' similarity subtest score on the IQ testing, that's the subtest score that measures intellectual horsepower, reasoning power, is very high. 75th percentile, 84th percentile, 98th percentile. Their reasoning and thinking score is so high that they oftentimes do not present as disabled as another child that's exactly the same with a similarity score that's in the middle, the 50th percentile rank. So the twice exceptional child has a much more difficulty in getting quality services because it's the issue may often be a hidden handicap. It's not visible. The kid's not in a wheelchair. They don't see the handicap. They don't sure it's really there. And if the kid would just try harder, the kid could do well. And you hear that so often. And that has to do in large part with the educators that one are making up the IEP team, but then also as important, the individuals actually providing services, the special ed teacher, the regular ed teacher, whoever else it is, having an understanding about what I call subtest scatter, and that the kid is so high in this area but so low in that area, and that the kid does have some serious deficits. And that's discussed in chapters 10 and 11 in our from Emotions to Advocacy book. But it's also what I had many of my parents do when I had a case. If a kid had, let's say, dyslexia, I had them join one of the national autism organizations. Or if a kid had autism, I had them join one of the dyslexia, like the International Dyslexia Association. When parents do that, then they see that these issues are not unique to that particular disability, but are same, because this issue of a bright kid who also has the so-and-so syndrome is universal, and that's in every area. And yet it feels to the parents so unique, and yet there might be another kid down the hall who has a totally different disability, but also is very, very bright and running into the same problem in the school district. So there's not an easy answer for that.
Yeah.
It has to be. You have to go in and do education of the staff.
Okay. Well, I have several questions from different parents. What's the best way for me to educate school personnel about Klinefelter syndrome? And then I have identical questions from parents of children with XYY and trisomy X. How should parents educate the school system about X and Y chromosome variations? Because very often these children have, have normal IQs, but they certainly have learning disabilities. And so it's the question of how to identify those learning disabilities, because they're frequently unable to read despite having IQs of 100.
As you were explaining the question, I had flashback to my own son. When my son, I have two sons, both LD-ADD issues, and one of them was, in fact, had an IEP for a while, and then I yanked him out because it was garbage. And I remember at one point, and it was about the 8th grade, and the kid was having some issues with one of his teachers, and I had an old LD textbook in my bookcase by Janet Lerner. She was one of the deans in the field, and I scheduled an appointment to meet with the teacher, and I said to her that we spent the weekend with another family, so-and-so, who's a special ed teacher out in Powhatan County, and she was telling me how she's pretty sure that my son has learning disabilities. And she said she thought she had this and she thought she had that. And she gave me a book to take a look at, and especially focus on chapter so-and-so. And I don't understand all this stuff, so I'm going to leave it with you. And I'd like to meet with you next week and have you tell me whether or not you think she's right. And whether our friend of the family, who's a teacher over in Powhatan County, is right. And if so, what I can do about it. And if there's anything that you can do working together. And she said, well, by all means, certainly, Mr. Wright, I'd be delighted to do that. And then I got with her a week later, and by then she was sold, and I didn't tell her, that my son, I didn't tell her history. It was in the file, but she never saw it, that he had an IEP years ago. Cause I figured I had to get to her. I had to spin her. I had to turn her totally around without doing it at gunpoint with a hammer, because when you do it that way, it's not going to happen. Just the walls go up and the doors get locked. And when you come in as the expert, then they don't hear you. So what I try to do most often, most scenarios, is I try to get whoever is working with the child, who's independent of the school and has some kind of a letterhead, an MD, PhD, a psych, whatever it might be, to write some kind of a letter or an evaluation, but sometimes just simply a letter that explains, markets themselves and explains what's going on with the child, what the child needs and why. And when the parent goes in and tries to do it, so often the walls go up and the school does not hear them. And so that was why I used the textbook by Janet Lerner. It wasn't me, it was Janet Lerner, and I don't understand, it's help me understand. And when you say help me understand, then the dependency characteristics for the educator kick into place, the codependence issues. They want to help. People do want to help. Okay, so.
All right. Well, it's 10 o'clock. I have other questions, but I'm not going to be able to answer them or to ask them at this time. So I want to thank Pete Wright for the webinar, and I thank all of the people who participated.
Thank you very much. Good night.